Same order. Yes.
Item 9.
Eight weeks, same order.
Item 10.
Eight weeks, same.
Item 11.
Six weeks. Same order.
Item 12.
Same order.
Item 13.
13 my lord, it has been complied.
13 is complied.
Yes, sir. Here, my lord, the specific direction was to dispose of the representation, which was carefully scrutinized and it was disposed of.
When? On which date it was disposed of?
It was, my lord, 11/11/2025.
11/11/25 is order. Court order.
They have communicated the same. This is order dated 11/11/2025.
Correct.
Thereafter, it was communicated on 16/1.
16/1.
Yes, sir.
They communicated. No.
Order dated 21/2026.
20 January.
Yes, madam.
After issuance of arrest warrant, they have done
Yes,
everything.
yes.
Give that. Just we'll look into.
Because of the sudden allotment, we could not take our
We'll look.
inquiries.
We should take the decision. Who should take the decision?
My lord, here directed to contemner is D. Naik.
No. Who should take the decision? Direction was 11/11. Go to that order.
My lord, I'll tell.
11/11. I have got this one. But that advocate is not here.
No, my lord.
Without him, how can we pass the order? Well, at least, of course, it's a matter to court and the contemner. But
No, in fact, the
call this
problem is urgent publication of the single bench list. Some of the
that's what.
bar members could not.
On 13/2
13/2.
to verify whether
The order has been
the
complied.
compliance has been done properly.
Exactly.
Okay. Yeah.
Item 14.
14, my lord, first time it is coming. It is dated 10/10/2025. The specific order is that to treat the sports certificate
Correct.
as it has been treated in case of the
That's
others.
having requisite. It's a valid certificate.
Exactly.
What they have done.
No, my lord, first time I have no.
Issue for his notice.
Well, may I take instruction?
Huh?
First time it is coming, may I take instruction?
All right, in this case, anyway, period of 8 weeks, they were asked to do.
Miller?
They were asked to
Yes, ma'am.
act upon that certificate as if it is a valid certificate.
Valid
8 weeks. That they have not done. Issue police service. Next.
Item 15.
Miller first time, it is order dated 26/9/2025 at page 10.
Huh.
But the order dated 31/7.
We duplicated another order. No?
Another order.
8 weeks ago, the another order which we have duplicated in this. The other order is dated 31/7/25.
31/7.
20851 is issue police notice. Yes.
Item 16.
Till next date of hearing. Issue police notice. Yes.
Item 17.
17 Miller, order dated 22/8 at page 8 Miller.
A certain very
Last time it is coming.
compensation has been paid in respect of subject plot before so it's police notice. Next.
Item 18.
Our circumstances.
This is also first time.
Appeal succeeds, appellate GIA case having been failed, the interim judgment is modified, fixing was 90 for the following date for sanctioning and releasing the granting aid in favor of the appellant under the provisions of so input as against the first of lecturer in the degree wing of college and grant all sanctions entitlement with retrospective effect, which should include arrears as well, so it has to be completed within an outer limit of 2 months. Police notice. Next.
19.
19 कह रहा देखा मिनिस्टर
Same order.
19 मोबाइल फाइल में
Item 20.
Particular in the matter. Same order.
Item 21.
No. Complete the entire exercise in a period of 3 months. When the order was issued, 12/9. So 3 months will be 11/12. So 11/12, now 11/1 is over. Issue police notice. Yes.
Item 22.
In all cases, issues emergent police notice. Returnable on so and so. Post the case on 13 in some matter, 20 in other matters. Alright. Next.
Item 22.
Same order.
Item 23.
Second date of the order. 13/10. Let me see if I can read. 8 weeks. 13/7. 8 weeks. Yes, police notice. Next.
Item 24.
22
22 police notice we have issued. You are for a complainant. Complainant.
Yes.
Yeah, issue.
So item 1, 2, 4
Ah.
and
1 to 4.
21, 22.
That's why issue notice is
Issue notice. Issue notice. Issue police notice. Yes. You sit down. You came running to the court. Sit down. Next.
Item 24.
Whether list is not exhibited outside.
It is not communicated.
This is
Because
exhibited.
this all of a sudden.
All of a sudden,
Single.
Some of the files are open.
In every case, we have taken care of. Okay. We have not dropped even one cutum. We'll hear the other side also. Little hearing we will give and then we'll decide. Next. That's all that takes the two. In our certain conditions, we have to submit and 8 weeks issue police notice. Yes.
Item 25.
14 tests. 8 weeks, 14, 10 weeks. Well, yes, same order.
Item 26.
Yeah. Same order.
Item 27.
Wait till next date of year. Yeah, same order.
Item 28.
This is 17 years. It is a period of 8 weeks. 17, 10 will be 8 weeks. 14, well, same order.
Item 29.
University. Modification is there. You said. Column 13. Yes.
Item 30.
30 is.
My lord, kindly pass over this item because my senior is not yet appear. Kindly pass over.
You are for petitioner. Petitioner. Huh. 30. This is for review.
Sir, so mo senior task eporjento asinandi to se kole eti tha.
But I am not waiting now. Only
Yes,
one
sir.
matter. Bring
Yes,
it.
sir.
First.
Yes, sir.
First.
Thank you, ma'am.
There is only one matter.
I'm sorry, my lord. I beg to pardon. Item note 3. I could not appear before lordship in time.
3.
Item note 3, my lord.
3 we have issued notice now.
Oblige.
Police notice.
Police notice.
Oblige.
Matter will common matter.
I may be pardon, Lordship. I may be pardon, Lordship. Lordship, I may be pardon. I am in the VC.
Yes.
In fact, my item was 19, Lordship. 19. I missed the list because
Yeah.
Item 31.
When sitting is little changed like this, as has happened today,
Yeah.
are you not going to inform, the registry is not going to inform in the bar association?
Yes.
They will inform.
Normally, they used to send a notice to the bar association. It has been pasted in the notice and also sent in the WhatsApp.
Correct.
So, but at the earliest, it could not be done, possibly because of paucity of time. We think so. Because we have also not been intimated. File has not been settled.
Wow.
For that, bar members could not be.
Yes, whether what is the best?
31 that I have to the respondent. Because of this shortage of time, I could not get the file.
Indeed.
No, so the applicant is not there.
On 20th, we'll have it on 20th February. That's the request of. Item 15.
His appearance is
1-5.
Yes.
1-5, we should notice. na?
Police notice was
We have issued police notice.
Interested for
complaint.
Okay.
Password.
So that also on 14 on 20th. On 13 you can put it. You tell that advocate, he should not necessarily come senior. His senior was coming, na? Inform him not to bring his senior.
ଏଇଟା ପରେ ଗୋଟେ ନର୍ମାଲ
24 matter, retable of 24 regarding pen color.
Is a retopil minor
Item 2 of the list. Item 2.
Yes, but not mentioned.
My lord, I may be, pardon my lord, I am not feeling well. I may be accommodating for the day for item number 31 to 40, my lord.
31 to
31
40.
to 40, my lord.
We'll have it next week.
Next week.
31 to 40 we'll have next week because Panda is not well. Mr. Panda is
Great,
not well.
grateful.
Okay.
31 to 40.
Yes.
What's the pencil machine?
Yes.
31 to 40.
It is not well.
If you are not well, we'll give time to you also. Yes.
My lord, in this case, the
Give. Yes. Item 1. Item 1.
item number 12.
Item 12.
Yesterday this matter was there. Minority commission. These said it is covered. Again, we appeared today in the list today.
Now let us see when it reaches. Yes.
Item 1, I am for the petitioner respondent, number 1 to 3.
Respondent.
Yes, petitioner respondent. And government has filed this appeal. Let them place one.
Let them. Yeah.
Item 1, my lord, but I want to submit. This matter was specially assigned to a council. It's no more. Assigned to a government council is no more. So further assignment is required in this case. And I was told that when the matter was before Honorable Justice, Chief Justice.
No, anyways, when do you want to argue? We cannot go on like this.
No, my lord.
Tell us when we will argue.
Some instructions were sought for.
We do not. If you want to argue. Otherwise, leave it to us.
My lord,
We'll hear this, we'll do that.
Lordship, may call this matter next week. I will bring that.
Finally, we'll.
Yes.
Because it cannot go on like
No,
this.
no. Next week or a week after.
You tell whichever date you want to argue. That day you have to argue.
Yes, yes,
We cannot have again and again posting the other.
Only assignment.
Please take over. You put down a.
We are affected party.
1 second, sit down. You pull down a date from the calendar. That calendar date you have to argue.
Yes.
Let them say all stories.
17th, my
Yeah.
lord. On 17th.
You pull down a date from the calendar. It's a date in the calendar.
17th of February.
Okay. Call this batch of matters on 17 February 2026. First off, this date is pulled down by the learned AGA from the court calendar after giving a lot of thought and assuring that he would not seek further argument. Adjourned. Yes. Item 2. Yes, sir.
My lord, here I have challenged the judgment of the learned single judge dismissing my writ petition on 2 grounds. The first
Not
ground,
with clean hands.
first is not with clean hands. Second is the advertisement was floated in the year 2015 and I approached this honorable court in 2024. My lord, I have given an explanation in my writ petition that although advertisement was held in 2015, the result was published in 2019. Thereafter, I sought for information under the RTI Act because my OMR seat was manipulated. And I got the information in 2023. And thereafter, I filed this writ petition. So, my lord, when fraud has been committed, there is no question of delay. That is one of my submission before your lordships.
If there is fraud,
Yes.
when Babar had come, so
No, my lord.
limitation will not run.
No, my lord. If your lordships will look at the OMR seat, my lord, how it has been manipulated, my lord, may kindly appreciate one thing. My lord, if your lordships will give me a chance, I will produce the original OMR seat, which I have obtained under the RTI.
Why you did not produce before the learned?
But that was produced. But the learned single judge has said that you have partially produced it, partly produced it. But that is not correct. In the writ petition, I have categorically avowed.
All of it
Well,
at the request of the
yes.
counsel for the appellate, who wants to place on record the
The original.
entire original OMR sheets.
Obtained under the RTA Act.
In contention that learned single judge, single judge's observation that the sheets were partially produced before him is not true, is not true.
Item number 3.
Non-production may result into dismissal of the appeal on that ground itself.
Yes.
Yeah.
Item 3.
May I please?
Yes.
Well, it's a state appeal
Yeah.
challenging the order of the Hon'Ble single judge. It is at page 36, dated 26/9/2025.
Yes, sir.
So, my lord, before begins, there are two orders. One is dated 26/9 and another is dated 29/2025 by the coordinate bench.
One is
26/9/2025. Another is 20/9 of 2025. This is in the board, my lord. 2 minutes.
26/9/2025.
25. Another
Date
is,
of the order.
yes,
Another order is
29/2025.
20th of September.
28th
yeah.
September.
Two orders by the same judge.
Same judge.
Yeah.
Different dates, man.
Okay. Is there any conflict between them?
No,
No.
system.
In fact, the
No conflict.
26th order was passed on the basis of the order dated 29th.
But although it is same, one is elaborative, another is subtle.
Yeah.
Then while the crux of the point is, as per the rules promulgated under 309 my lord, 2021, all the government,
rules?
all the, yes, ma'am. That is Odisha government servants,
Seniority rules.
no, my lord, it is conduct, my lord,
Conduct
amendment rules. Of 2021, my lord. As per the said rules, my lord,
No, what is the grievance? What were there was? What
grievance is non-submission of the property list for the purpose of promotion to the next hierarchy, that is sub-inspector of police to inspector of police. And the date which has been specified, it is starting from 1st January to 31st January 2025.
31st January to 1 year.
No, 1 month.
1 month.
1st January to 31st
Let
January.
us read let us face that
Yes, ma'am.
the text of the rule itself.
Can have a glance to Annexure 8, my lord.
Annexure 8.
Yes, ma'am.
This is amendment rule.
Yes, ma'am. Amendment rule.
Amendment to 1959 rules.
Yes, ma'am. 24th June 2021.
So rule 21, original rule 21 is substituted now.
Yes, ma'am. This rule may be called as Odisha Government Servants Conduct Amendment Rule 2021. my lord. Now coming to the
They are group A or group D. What is their designation?
their group A.
Group A?
Group A.
Group A to Group D, all the employees. Then
So
come under this.
this says no government employee shall acquire property, immovable property, by way of sale, exchange, gift, lease, or mortgage. Correct?
Yes.
Except with the previous sanction of
Sanction of the authority, competent authority. And they have to submit the report before the authority concerned, starting from 1st January to 31st January.
Why that date you are saying, I do not know.
What is that?
That date is not internalized in the amended rule.
Note 1 is only there.
Huh?
Note 1. Judicial officers is something different. It's a different one.
No, why that date which you are now saying before us
Yes.
is not internalized in the
No, Miller. Kindly have a glance to clause 4, Miller.
last 4.
It is at page 56. May I read it, Miller?
Yeah.
Every government servant from the level of group A to group D is required to make a true, complete declaration of all his assets,
You are right.
movable, immovable, and the value thereof, as on 1st January every year online in HRMS portal, on or before 31st January of that year. The declaration shall contain the details of the particulars of the officers, assets, and must include and specify the asset which are held by him or in the name of his wife, children, or other dependents. In case of female government servant, in the declaration there shall be a specific mention as to whether the same has been acquired out of her own
Her source or husband's source?
other source. I'm not on that point, only on that particular date and the period.
You are 3. No, 4.
I'm in 4.
4. It requires two things as we face it now. Textually speaking,
Online
declaration of assets A, B, C, D. That should be before 31st of January of every calendar year.
yes.
Then the value of A, value of B, value of C, value of C, D. That is on or before 31st January. On or before, that will be before 31st
January of the year.
year.
My lord, another point is there, my lord. Every year, how they will send it? Every year online in HRMS portal.
Yes. Mode is also mentioned.
Exactly. The mode of submission is also mentioned therein.
Yes.
That is the specification of the rule.
Yes.
Particularly in this case, my lord, this has not been duly submitted at the scheduled date and time.
Submitted but not duly submitted. Is your case not submitted at all? Is your
Not submitted.
not submitted
Yes.
at all?
So I am giving the figure, my lord. For filling up the post of inspector of police, there are 687 SI posts are vacant.
Can you request your friends not to disturb the judges, if not the lawyers? Because otherwise you also disturb when their matters come here. Yes.
687
Matters require application of mind. Understand this. We can do our job, that will not help you. Unless you allow us peaceful application of mind, we will not be able to do justice at all. Mechanically, we'll pass order. You know what will happen. Yeah.
My lord, there are
Your case is that they have not submitted property particulars in terms of sub-rule 4 of amended rule 21.
2020.
That's your case.
Yes, ma'am.
So what you wanted to do? They did not.
Thereafter,
Huh.
taking into consideration as 687 posts are there, out of the same, I have taken the figures, my lord, 427 they have submitted in due time. Due time they have submitted. The rest of the persons they have
They
not,
have not submitted.
not submitted. Taking into consideration all these aspects, J Department has made a circular, and by extending the date, that is on 28 February 2025. my lord.
Where is power to extend? Government is bound by the rules. 364 Supreme Court, Constitution bench. Government is bound by the law it makes. Where is the power to extend by circular? Any power is given, power of relaxation, extension, etc.
I'm submitting that particular extension order, my lord.
Yeah.
This will clarify.
Is it really?
My lord, at annexure 2, my lord, at page 20. It is into the writ appeal.
This is the extension of time by whom?
It is by the Additional Secretary to Government, Department of GML.
It is worse than a leave letter. It is worse than a leave letter. Where is the order of the government? Where is the power to the government to grant relaxation? To the
Even if
officers of their
rule
choice?
does not specify. So
Ah.
that I have not annexed, my lord.
Oh. Then what is the next level of the case?
My lord, then it was further extended up to 31st May 2025, my lord. Within that period also, these petitioners, those are in number in 51, they have not submitted the same.
Therefore, what you wanted to do to them?
My lord, they will consider for the next year, my lord.
Consider for, no, we want to know. This mandate, if not complied with, what will happen to the employees in Karnataka? Such
They will be
employees are
considered
there.
for the next year and they will not lose their seniority, my lord.
Therefore, they can acquire property, they can retain property in a discreet way. They need not publish it to others at all. Only thing is, their case will not be considered for promotion.
No, my lord, they have to submit it.
If they do not submit, what is the action you are going, what is the risk? Is it a misconduct?
It is a misconduct.
Where is that?
Yes, ma'am.
If it is a misconduct,
Yes.
what action you have taken against unscrupulous fellows to throw them out of the employment? Otherwise, whole system will collapse under corruption. Which conduct rule prescribes
This is
the discipline and which is the misconduct, enlistment of misconduct? What is that?
CCA rules, my lord.
CCA rules. Is it misconduct? You said they should declare. If they do not declare, what should happen? Rules will not say that.
That is in PMR, my lord.
You do not know. If you say all
Police-
the abbreviations, I will not understand. I am from another state.
Only police manual rule, my lord.
But what is that?
Where is that? You cannot go on like this.
My lord, I'm reading that ones.
Yeah.
The return I'm reading out in case of the female government servant.
Yeah.
In
No,
the-
in case of female government.
No, I'm coming, my
to
lord.
say
Yeah, no, they
whether
are-
court sees her own or her spouse.
My lord, they are out.
Yeah.
That is there. The return shall be placed in the public domain for access of public. A copy of the return shall be accessible to the localyukt for the information. In the event failure to file the property return in time, the concerned government servant shall be liable to be disciplinary action. An employee making a declaration found to be materially incomplete, misleading or false shall be liable for the disciplinary action in a major penalty.
Where you are reading that?
I'm reading that clause 4, Miller. Half of the way I have stopped.
Half of it, yeah. Last part of it.
The last part.
A copy of the returns shall also be accessible to the Lokayukta.
Yes.
Also.
Yes. Yes. Then what happened? What action they challenged before
They
the
have challenged only that particular period which has been allowed by the Honorable Single Judge, but its order dated.
where is the order that was challenged before the learned single judge?
My lord, it is at page 36.
No, the order which they had called in question That circular something, no? British statement details signed, so. Mr. Mohanty, this is such an important matter. Your performance is not impressing us.
I'm sorry, my lord.
Admittedly, they have submitted their returns on 20 September 25 and 21 September 25.
Yes,
It is not online submission.
no,
Online submission alone is permissible.
alone is permissible,
Secondly, that submission beyond the cutoff date is not permissible.
not permissible.
It is permissible, they are bound to this one, but they undergo the disciplinary action.
Even after the extension of the dates.
No, question is, how government officer, secretary will issue a letter saying that extending that? How can that happen? That cannot. The secretary is not a Mughal ruler. He will do anything.
And my lord,
Rules are there. They have to follow the rules. Who is the secretary to issue that extension? Where is the power?
and my lord, they have not also submitted in the HRMS or online.
No, question is not that. The object of these rules is to ensure probity, transparency. Otherwise, not all government servants, a section of the governments are as bad as can be. There is one judgment of the Apex Court where it said what would happen if the corruption is allowed in the government. It has 2 paragraphs with for every sentence. If this is for corruption, this is for corruption. 96 Supreme Court. Can anybody take out that judgment? Anybody? Can anybody help us?
Yes, madam.
Take out. Corruption is the cause. It begins that way.
96 Supreme Court.
And why secretary issued that letter? It cannot be for a song. If secretary,
When the rule specifies,
unless the rules authorize him, and see that text of the letter, format of the letter, syntax of the letter, content of the letter, there should be a normative process. All rules are not at the mercy of the secretaries. They are not our rulers. Their rules are made, or they are published, promulgated, published, and according to rules, government servant should do. Otherwise, where the state will go? Where should poor people go? We have seen so many cases coming for issuance of birth certificate, cash certificate, change of khata. And for more than 6 years in Ganjam district, charge sheets have not been filed. It's on record. And police officers, not necessarily these police officers, but I'm telling what is happening on record. On record. So what the learned single judge says?
this is at available at page 36, my lord. The operating part, my lord.
No, you wanted to take action against them for non-filing of property details. They have not filed property details according to you. What you did to them?
As per the rules, action will be taken, my lord.
When will be taken action?
Well, this
You only have violated the rules by extending the period.
This is the recent 2025-26, my lord.
Correct.
And the order
No,
is of
why they went-
26/9/2025.
Why you went to the learned single judge who appears for the police officer?
Because we have submitted our property statement
When did you-
offline.
Tell that.
After the cut.
After the cutoff date.
After the cutoff.
Cutoff date. And the reason is because we were all appointed in a one batch, 602 sub-inspectors have been appointed on 17/1/2/1/1917. Our appointment is there.
2/1
2017. We are all
2017.
2017. 2017. I'm sorry.
2017.
17 were all appointed.
Okay.
So as per the police manual, PMR, our promotion shall be after 10 years. That was 10 years.
No, we are not on promotion.
No, my lord, just I'm telling what I'm driving to say, my lord. Our promotion is that. But as per the by way of executive instruction, they have changed the promotion to 7 years. So our 2024 batch having 7 years tenure, they are promoted. Thereafter, for our batch, they have amended the rule. There was an amendment. As per the amendment, it is 8 years. So our promotion will be due as per this on 2026. 26. So 26. Because
Why 17 and 8 is how much?
well, that is one date is now falling short, Miller. That is where. So on that day, our promotion will not be due. It is only in 26. As per the rules they have, which they have amended. Thereafter, they have again amended.
Mr. Monty,
Well,
take us to order dated 20 September 2024.
That is page 36.
36.
Yes, ma'am. Operating period is 37.
This is 26/9/25.
Yes, ma'am.
We are asking you
20th.
20th of September.
This is in another matter, my lord.
That
is
because
the
that order is printed partially in this.
yes, my lord. That is in sub-item. I am here. It is here. ma'am.
The item which one?
they are covering this.
This is in sub-item number 3. Yes.
WA 1620.
Can I place it? If your lordship permits me, I can
This
place
is
it.
1620. ma'am.
That 20.
And
To
is
direct OP parties to consider the candidature of the petitioner in special CCP going to be conducted pursuant to the state police headquarters letter dated 7/9/2025
yes.
under an examen for promotion. Hey, you don't have to when I'm reading. Of eligible sub-inspectors of police to the rank of inspector of police by accepting the hard copy of his property statement or by opening the portal for a limited period to facilitate as he is otherwise eligible for promotion. So you wanted acceptance of your hard copy of declaration of assent.
Smell.
Rules, where do the rules provide for that?
As per the
The hybrid rules is not there, Miller. That is there. But the practice is, for that we have come to this honorable court, Miller, before the single judge, praying that we may be allowed. Because from the time to time, they have extended.
How was the rule?
They have extended the time.
Pre-amended the rule 21, read 21. 21 is amended only in 2021.
Yes, ma'am.
Rule 21, as it existed prior to amendment, what did it say?
They don't have.
Do you have a copy of that rule? Unamended rule?
It is a rule of 1992, my lord.
Give
Himself. It is there, my lord.
How
Page,
it reads?
page 53. ma'am.
Page 53.
Yes. Annexure 7.
Go to 53.
May I submit, ma'am?
that is criteria of promotion rules.
Huh.
Conduct rules 21 prior to
Conduct of Pratham. That is dealt with in rule 21. Lord, I have the hard copy. This use that.
Let's me follow page 40.
They have made 31st March of every year.
That was in March. But they have changed by the.
This is acquisition case. This is reporting case. The declaration contained details The charges by the name of wife, children, dependents of the non declaration shall be written with the officer in his own hand and submitted in a sealed cover to the authority as directed there. In terms of the petition, responsible for its reservation. It shall be obligatory on the part of the government shall subject to declaration every year. And the event of it is also and to be liable to basically actions. This is a declaration bound to be say also be liable for disciplinary actions to major penalty under the provisions of respecting discipline. No, it's a regular requirement, whether you one wants promotion or not.
Why this you are linking to the promotion?
Well, to my mind, if your lordship permits me, to my mind, it appears that there are two contingencies. If you do not submit a property statement, a disciplinary proceeding may be initiated.
No, shall be initiated. Yes.
Then the second is that authorize also, if you have assets more than your income,
That is disproportionate.
disproportionate on the Prevention of the Corruption Act. If both the things are there, my lord, then if the disciplinary proceeding is there, it will be kept in a sealed cover. If the Prevention of Corruption Act, there is a proceeding and charge sheet has been submitted, then I will not be considered at all. So in order to meet that exigencies, they will require the property statement before giving the promotion. It is a prerequisite for
Promotion also.
promotion. It is a prerequisite. So for the present, my lord, since no disciplinary proceeding has been yet initiated against for non-filing, and government has been extending time to time, and we are working in the field where the net connections are not there. So we are facing difficulties. That is why we approach that since you have already extended the date, allow us one opportunity to hear you. And the DPC couldn't have made because they have not received the CCRs of all the concerned zone of consideration.
No, question is not that. Question is not that.
So,
The duty to submit the declaration is independent of government's duty to consider your case for promotion. You are not filing or filing, this is irrelevant.
Yes.
You are bound to declare what are your assets, what are the assets you have brought in your name, in spouse's name, in children's name.
right. So there is no dispute about it.
There is no
Dispute.
relaxation in that, no concession in that.
Right.
We are bound to declare
Yes.
whatever assets we
Yes.
acquire.
That. But I am.
Prerequisite for promotion also.
Yes, madam.
Where is that rule?
That is there in the rule sheet, the amended rule.
They have cited.
Those who have not filed will not be considered for promotion.
No.
That is their stand.
Yes.
Therefore, you went before the learned single judge.
They give us one opportunity to submit it offline. Because
We are appointed in July 2017.
because the online portals has already been closed.
That is
Yes.
closed.
After the cut-off date, it is closed.
Up to the cut-off date,
No.
all culprits.
But your lordship will see, even after the cut-off date prescribed on the rules, the government has been extending
No, there
time.
is no extension in the IOF.
Right.
We declare that
Right.
way.
But then all those persons who have
All the
applied,
persons, whatever
all
happen,
their
happen.
promotion has to go.
Yes.
But I am not there. But even in cases of IAS officers also, Chief Secretary on also.
We do not know. If those cases come before us, we will tell the chief secretary to go home only.
That's right.
As we are going to say in your case. now.
I am not talking. I am telling that what is this case about? CCRs were not collected and the debts were
Not collected.
CCR has to be collected from different SPs because persons are working in different districts.
That's all right.
30 districts.
That's all right.
Yeah.
Where is it? Where is your submission of the assets details?
That I have not submitted in time. Subsequently, I have already submitted.
Learned who all say with this statement?
I have,
You have not submitted in.
I have submitted.
No, not in January.
Nobody.
No, Lord.
On being asked.
But that is the case about
That's fine.
because
Therefore, I'm making the notes. On being asked, all learned advocates appearing for the respondent police officials very specifically and repeatedly say that their clients have not have filed the property particulars in terms of rule amended and unamended rule 2021. But after the cutoff date, once again, whether cutoff date prescribed by the rule or prescribed by the letter of the secretary, which date?
Letter of the secretary.
They also say that they have not filed, they have filed these property particulars
Offline. Offline.
after the expiry of the cutoff date prescribed under amended rule, under Rule 21, amended, unamended.
And the extended
And also-
time there too.
The so-called extension granted by the secretary wide letter stated.
This is my lord 28 to 2025
2025
and 19th April 2025.
and 19 April 2025. For all the previous years they have filed.
yes,
My lord, here the case is,
We want to know whether for all the preceding years, have you filed your property detail?
we have always been filing the property statement, my lord. But this year, what happens?
We are asking you.
Yes, we have been filing.
We want to know whether Mr. Vanti, you have to tell whether these officers have filed the property details in terms of this rule for the preceding years.
Preceding.
Preceding year. And you should tell who is that secretary, who has issued that letter, how he issued, where is the power, where is the format, where is the power, where is the format.
Yes.
It cannot be by a letter. If power is given, it should be in the form of a government order.
Yes.
Otherwise,
That I will-
it gives a scope and for assumption by the court that something has happened in a wholesale way. That will not permit. Tomorrow, you have to file that explanation. You should tell under which, Mr. G, under which provision there is which provisions of the rule. The secretary has got power to give extension. When the rule says so and so, where is the power to the secretary?
The rules,
Where are the rules? Just
There is
show the rules.
nothing is there.
Nothing is there.
Right.
No
My-
rule is
my
spelled out
knowledge-
in this.
To my knowledge,
Cause extension, there is no rule as such. Only they have, by executive instruction, they have extended from time to time, and they have also amended.
When there is law occupying the field, no scope for exception of executive power. This is decided in Sahib Ram Jawaya Kapoor versus State of Punjab more than 60 years ago, 70 years ago. Justice V.K. Mukherjee's judgment.
Well, coming back to this, our position, my lord, what is the case about?
Yeah.
The case about is, they have a lot of, there is a coordinate bench decision, number of coordinate bench decisions of our High Court, my lord, by granting them to offline, my lord, because
Sure,
it is not hybrid mode. It is not hybrid mode.
No, we don't know. Where are those judgments? Give us.
That
Whether
is-
the High Court is given power to extend?
Yes.
Here.
The High Court has permitted to submit us.
How?
Yes.
How High Court will do that?
226.
We are not Mughals either. We are bound by the rules.
Because it is only
Know that. So-
only when they have been extending from time to time.
That's
It
what
is
we
our
want
High
to
Court
know
has
now.
extended.
We'll draw a curtain now. Where is that time to time? Which how High Courts will extend that? How government, how secretaries will do, how judges will do. Then where is the value for the law?
Coordinate bench ଆମେ ଲେଖିଛେ ନା।
Give that copy. Whether that is a court of issue.
But my learned senior friend is somebody. the coordinate benches, the judgment relied upon, there is
They have never challenged.
said to conduct a reviewed PC, he considered the case, those who have not submitted in time. That was the finding, if I am not wrong.
Even for those who have not submitted.
Yes, ma'am. By way of a reviewed PC. That is the finding. Let him submit.
It is their circular, Miller. They have given a circular recently.
Give that judgment.
But here the case, Miller, just a moment. Here is what they have asked us to submit the property statement. Now the substance is to give the property statement. But the mode they have prescribed through the HRMS only. But here the honorable single judge directed us, you just the input order, Miller, it is transparent in that. You just today itself, you file it offline. Offline.
How judge will do that? Therefore, they are in appeal.
It is a series of decisions of our coordinate bench.
Do that.
That is there.
We
I am
do
giving.
judgments. We are not Mughals. We are all bound by the law. The judges are more bound by the law. Give that judgment.
Yeah.
Give that. Only God should save your state. Nobody can save your state.
And moreover, this writ appeal is also not maintainable, Miller.
That we will look into.
President on extended body of judgment. Even supplement has extended body of which
This is by learned single judge.
Miller,
Learned single judge.
it was never been challenged by the state.
That's all. That's all. That's all. Any division bench judge
This is also another.
এইটা তো আমি দিয়েছি
is another
Okay.
single judge.
Single.
Give all the judgments. No discussion. Yes. Yes, now, sir, tell your points. We have understood the case. What's your point?
My
Article, give the dictation.
yes, ma'am. My humble contention is,
First contention is.
yes, ma'am. When 2021 rules clearly spell out
Right down. Yes, he has written. Continue.
under clause 4 that the specific date or submission of this property report under the online HRMS, the same has not been submitted in due time within the time stipulated. The secondly, Miller, so far this Honorable Single Judge Miller has passed this order, which is diverse the statutory rules, as has been governed in a particular field,
Yeah.
that has not been adhered to. But the judicial pronouncement should not be travel beyond the particular.
Yes.
And I can conclude my last mala. The judicial order cannot bypass the rules, which is prevailing.
Yeah.
In nutshell, my points. And to add, Miller, one thing. Even after extension, my lords may accept or may not accept that the version, the properly it has not been formatted or it has not been articulated in a proper manner. Even if after the extension, twice it has been extended, the same has not been submitted in that extended period also.
Yes.
Yes.
That's your case. To put it succinctly, the amended rule 21 is mandatory. Assuming that your secretary had power to extend, at least within that extended period,
It has not been.
the submission of property particulars has not been done.
Exactly.
Therefore, the court, learned single judge could not have granted relief to them.
Yes.
That's your case. That's all. Now we want to know why, how the secretary, you have to answer that question. Otherwise, we will make drastic observation against the secretary. What is his name? We want to know the name of the secretary.
Name is not by designation, it is
No, get that name. Otherwise, we have some good.
that I will take instruction, whatever my lord says.
Ask
Help
by
from my-
phones. They will argue and you ask by mobile phone. We will not give time for that. Yes, sir. He says that way. What's your answer?
What is their grounds? Their writ appeal, page number 9. Their grounds is. What is their grounds they have challenged? B. For that, the learned single judge proceeded to hear and dispose of the matter without affording any opportunity of hearing.
All right, leave it. We'll agree. Now we agree with you that they were given full opportunity. How to justify, sustain this order?
Then for that, the learned single judge, while passing the impugned judgment, failed to appreciate the amendment brought to the Government Servants Conduct Rule 59 by virtue of Government Servants Conduct Amendment Rule 21, framed under the Article 309.
Article 309. Is that how, that what the government is saying appears to be true? Then you convince us.
Then I'm
These
answering.
rules need not be followed.
Yes, that I am answering this now. My counter may kindly be seen. My counter.
No, tell, you are arguing.
Now I am on the question of maintainability. May
very vehemently submit that the inter-court appeal is not maintainable in view of full bench decision, which is that judgment, full bench decision. We will give you one. There is a full bench judgment, na? Appeal is not maintainable. In view of full bench judgment, etc., etc. Give that. Which is that judgment?
That 2 to 7, that full bench judgment of.
But it is maintainable. I have prepared a note.
Yeah. Any ruling is there?
Ruling I have given all the rulings. Even Privy Council I have given also.
Well, when Privy Council was there,
With regard to the mode, substance and form.
yes, first ground is over. Second ground?
Then, my lord, here this second ground is, they have from time to time, they have extended, and our promotion was not due. That is by executive instruction that was extended, and by that time, when they said the extension line department has not done, it is the extension by the GA department. But they have not also notified to us. This is the time extended. So had it been,
we will assume now. Where is the power to extend?
that is the, my lord, it is the government. Their stand is they have not extended. They have built up their foundation on the case, on the extended date. Because the number of other colleagues, they have also submitted their, which they have admitted. But by that time, we have not submitted, although that has been extended. Because the period, in my, I take a lordship, just a glass, my counter affidavit, Miller, that is page 14. One by one circular I am putting before my lord. How their action is not fortified with the proper reason. Not in the relaxation of eligibility criteria prescribed under rule because which I have said conveyed that our promotion could only be possible after spending 10 years of tenure. That has been amended by this notification annexure A, Miller. They have amended.
This was challenged before the learned.
No. What I pursue, Miller, because from time to time they have changed it, but in the last moment, this year, the last year, they have immediately in the month of September, they have declared we will be giving promotion on this, although it is not due for us. So by that time we are not ready to submit our property statement. Because of non-submission of property statement, our promotion is held. My lord's anxiety is to know about.
We have no anxiety at all.
My only question is,
Yes.
we had never expected that our promotion will be due in this year. We have expected it is in the 26. By that time, we could have submitted. But they have preponed.
No,
They have preponed the date.
Why you are linking your duty to submit the property details to your entitlement to promotion? Why are you linking them?
If because I am only discarded on the only sole ground that I have not submitted the property statement, although time is extended by the GA department, not by them. But our line department, the police department, that has notified us in the month of September 7/9/25. They have notified you will be given promotion. So you just submit your papers. You should show that you have submitted your property statement by 31st of January 25.
That means, Mr. Mahanti, is it your case that the period which has been mentioned in the rule has been preponed, and you have that is the predicament on your part not to submit
What
it?
he wants to say, Milord,
That is preponed, Milord.
what he wants to say is
That the requirement profile.
for consideration, the experience of 10 years was required previously.
No, that is the residency period that you are talking of.
That
No,
is what he is telling. Then the government in its own wisdom
Did it
reduced it to once to 7 years, then
8
again,
years, 8 years.
Again 8 years. So in our case, it was done for 8 years. So
on the 8
showing
years,
the
what
flexibility.
property list you were supposed to procure could not be procured because of the predicament that the residency period was preponed. And whether by then your time was there to submit it or not.
That is no time. That is expired. That is expired, Milord.
Now,
By that time,
you were not procuring your assets on these things in every year. You were not giving it every year.
as per the rules, we have been submitting that.
How then?
Because our exigencies, we are sub-inspector of police.
No,
And many of us, Milord, the only hazard is that we have submitted before the Honorable Single Judge. Only hazard is suppose we are in Koraput or in different places in urgent matter. Portal, many a times portal is not also working. So that if had it been hybrid mode, it is only mode. The object, my lord, the Privy Council said, my lord, that I have that decision may I submit, my lord, because there is a decision to that effect, my lord. It is a mode. The modes, the objective is we have satisfied, but the mode is something.
This mode was unknown to Privy Council. This mode, this technological development was unknown.
This is also Supreme Court says, Miller. Supreme Court also said. Our Supreme Court also said, Miller. That I have also got it, Miller. Our it is in umpteen number of cases. Miller may cite 76 Supreme Court.
Read.
1177.
What does it say?
The failure to pass a departmental test by the government servant after having put in more than 2 decades of service cannot stand in the way of enjoying the benefits of increment. The property paragraph I am reading out.
No, what Apex Court said is right. But that is not your case here.
No, my case is there is something. The mode is derailed. The mode
You have
is
not challenged those rules.
no, those rules are not challenged.
Rules are there.
No, my case is. But what they say, you have not filed your property statement within the time, within the extended time. So that is although they have from time to time extended and they have preponed our date of promotion. So which we are not aware of this. So all said and done, they have notified in the month of September saying that this is your promotion date and you show all the records having submitted your property statement. So when we are derived from this, although we have filed the offline submission, we have made offline submission in our respective headquarters, my lord, that was not accepted.
When it, yes, because rules not.
Yes, my lord. When that is not accepted, then
How many others have made already submitted?
many of
Submitted. Only you have not submitted.
because we are now 15 numbers, we could not submit because in different places in
Others were also in different places.
and might be in some cases we are in our batch we have 602 sub inspectors in a day we are appointed. But and our colleague and we most of us with the 50 now left out, most of us and one of us is a topper in the batch.
What we should do with that?
The credit, man, just here is the efficiency and the merit only for a mode. I am now been not getting the scope to enter.
You have not challenged the mode prescribed by the rule.
It is accepted by them. From time to time, they have said they have built up their foundation by saying that we have extended from time to time. So by executive instruction they have extended from time to time. Here we have taken a judicial decision, judicial observation that our time is extended. That judicial extension is now challenged in this appeal.
Correct.
So whether now on this ground this appeal doesn't merit in consideration, the appeal is not maintainable.
You have said that. Go to next point. Don't repeat.
Then my point is, I have already prepared this note, Miller. May I hand over this note?
This is which you have given now.
Yes.
Yeah. One more note is there.
My lord.
This in addition to this, you have another note.
No, this is one. This is one. I can pass another, my lord.
You are very gracious to us. Most of you will not give only when you ask us to share that.
So for this, my lord, at the threshold, the writ appeal is not maintainable.
You are only repeating the mantra.
Well, that is the
We have
best.
understood. Writ petitions. Now you can have a board itself on your court just. That writ petition is not, writ appeal is not maintainable. Understood. Again, right. Writ appeal is not maintainable. Writ appeal is not maintainable. Writ appeal is not maintainable. All right. Understood. Next point you are saying.
Well, I'm placing, my lord. I'm
like
placing.
triple talak, we have to say it twice.
Just because
What are the legal points? I think the legal points. Mr. Amonti, could you get the name of the officer, the secretary who has issued this extension?
In fact, though it has been issued by the additional secretary,
Whichever.
I got the name of the secretary.
Get who is the author of this secretary? We are otherwise we may affect the names of other secretaries. We do not know that. We don't want to do.
Additional secretary name is there. Name I got.
You have got the name?
Yes.
Who is the author of these letters?
That I will not get.
That you have to give.
Well, the second point is, in
First
this
point is over now. Second point is?
Milord, here we have wrongly or rightly, we have obtained a direction from the Honorable Court, Milord. Before this,
No, they say wrongly.
whatever it may be,
So we should not interpret
it may be wrong, but until it is stayed, that is holding the field. But before that, without any challenging that order, without challenging any in a writ appeal, they have given promotion to all the colleagues, junior colleagues. Without considering this case or without filing any petition like writ appeal, after giving the promotion, they have filed this, which is also contemptuous. The conduct, I am showing the conduct. And
the conduct of appellant government and its officials is blameworthy and culpable in as much as they have given promotion to the juniors
of the respondents who are similarly circumstanced. Second is over. The third.
The contentious will be that your lordship directed, your lordship sees that order dated 29.
29.
Yes. Your lordship directed them to consider their cases in the for promotion.
Well, by the coordinator bench, by the coordinate bench.
In the DPC. They didn't file any writ appeal against that immediately. They conducted the DPC without considering that in spite of the specific direction. And they only filed, after conducting the DPC, they filed a petition but didn't obtain any order of stay.
Petition.
They filed a writ appeal. Appeal without obtaining an order of stay. So, but deliberately, they are saying that they could have come for the single judge for extension of time to implement the judgment, or they could have sought for a review of that order, or they could have moved in writ appeal earlier and obtained an order of stay. They did nothing. They conducted the DPC without doing anything, bypassing the order of the court, my lord, without caring for the court, my lord. This is utter disregard of this court. Whatever will be the fate of the case is altogether different. But a judicial order cannot be bypassed by the whims of the executive.
You complain it to the contempt court.
That is all right. Since she is the conduct.
Yeah.
The case was, writ appeal was filed after conducting the DPC.
Internet consultancy submits that pursuant to the order of the learned single judge, the appellants have conducted the DPC and without seeking extension of the period prescribed by him, have now come up in appeal, and therefore the conduct should disentitle the appellant to maintain the appeal.
Smacks of madness, my lord.
Then any other ground?
Well, secondly,
Yeah.
the conduct of the opposite parties is this, because from time to time they have extended the time by themselves, and recently also this month because of the last order my lord has passed in this year. This is a circular, my lord. I have just in the, can I read it?
The order.
Unless it is part of the record.
Yes, your Maximus is the last order.
Last order, my lord. Just have a glance. It is they have submitted.
7/1/2026.
7/1/26. What they have done?
By that order, they have given another executive instruction by saying that this is if any defaulting employees submits the required property return after the DPC within a grace period allowed by the government and is found otherwise suitable for promotion, his or her promotion may be considered in the subsequent DPC. He or she may be granted a notional promotion from the date on which he or she junior was promoted, and his seniority shall be maintained. It is their circular. Pursuant to that, my lord's coordinate bench directed us to submit the property statement immediately.
May I pass on a circular?
Take it.
Pursuant to that, my lord, this 7/1/26 order was passed. Para 3.
Mr. Mohanty, there is one more letter now.
November.
No, 27th November 2025.
Yes, ma'am.
That is after the passing of the order.
Now, additional chief secretary has passed this, sir.
Clause 3 में
Should this.
Clause 3. If any defaulting employee submit the.
No, what we do not understand is how these secretaries go on trampling with the rules unless the rules are amended or the rules authorized. These rules are under the proviso to 307, 309.
Yes.
There is no Civil Services Act in your state. Orissa Civil Services Act is not there. Is there any such legislation?
No, sir.
No legislation. So they are all under the proviso to 309.
Yeah, this
309.
309.
And you also admit that the rules do not authorize the government officers to extend any period.
That is existing instruction, we have not said that.
Yeah.
Because of this, Miller, that 7-1 order is passed by the Parliament.
This is in the light of the order passed by the learned single judge. Because learned single judge passed the order.
No.
That is why
the division
September 2025.
No,
This is a fallout of November 2025, subsequent to the two orders passed by the learned single judge. Though they are not mentioned in that. This is an offshoot of the order of the learned single judge.
September 2025.
November
No,
2025.
they have, it is their practice, Milord. They have been doing this. It is the government, they have been doing, not offshoot of the signatures. That is not. Because they have already filed appeal by that time. Na? And in the appellate court, Milord, they have submitted it. We have obtained from them.
And the order letter 7/1/2026 is kindly seen, madam. By the coordinate bench. In that order.
7-9?
7/1.
7/1/26.
This order in this writ of
This order we have.
this in. Because they have seen. It is not offshoot of the single judge order.
The circular is independent of any of the direction passed by the single judge.
Yes, that is independent.
No, that division, that coordinate bench does not discuss any aspects of law. It disposes of the matter on the basis of this memorandum.
Yes, memorandum.
Whether memorandum is valid, whether such memorandum could have been passed by anybody, all that is not the subject matter of discussion.
No, that is not.
No, absolutely not.
Because it is only both considered to each other, and since this practice is going on.
Not they also contend that the additional chief secretary to government by the office memorandum dated 27/11/2025 has relaxed the period prescribed by Rule 21 and thereby facilitated filing of property particulars. Within what period should be filed?
First, 31st
Within this 31st
January of each year.
31st of
January
31st January of
2026.
each year.
मतलब paragraph 2 of that may order may kindly be
Clause 4
seen.
is very clear.
Paragraph 2 of that order may kindly be seen. 7/1/2026.
That is 1st January every year.
Every year.
On or before 31st
31st January of the year. And we have submitted.
It is submitted by Mr. Swasat Das, learned additional government advocate, that by virtue of subsequent circulars and letters, the time to submit the property details for the year 2024 has been extended till 31st January 2026. So the repeated extensions only shows that it is not mandatory, it is discretionary. And this is not the practice for this year or 25 or 20.
By letter it is mandatory, but in spirit it is discretionary.
I have a theory, sir. Within the extended period, that is 31 January 2026, in terms of para 2 of the said OM, comma, and other cases, namely writ appeal number 1672, etc., of 2025, having been disposed of with a coordinate bench, wide order dated 7/1/2026, comma.
No, it has not been disposed of.
Huh?
They said that, my lord,
Pass this order, na?
no, that is not disposed of, my lord.
That is a continuing.
In this case only.
Yes.
In this case,
In
Yes.
this case only.
And
this
this
is only
was,
recorded what has happened.
this was a
Court proceeding record.
hard time and again, my lord, full-length hearing was done. Then the government came out by telling that we are giving one more circular, let them
By the coordinate
file it.
in this very matter. Wide order dated, wide interim order dated 7/1/2026, comma. The appeal itself is not maintainable.
That I am not telling.
But your friend is saying it is not maintainable.
That is his point.
What is your point on this?
My point is that this the rule conduct rules, paragraph 4 of that 21 is not mandatory.
First, in view of the conduct of the government in extending the period for filing of the property details time and again
Over the years.
over the year, the provision
Should be
of
read as-
Rule 21 should be read as only directory and not
Not
mandatory.
mandatory.
And therefore, non-compliance of the said provision would not come in the way of respondents' claim for promotion to the next level.
That is one word maybe.
Yeah.
That is only it is mandatory in the letter, but not in spirit. That their amendment. This also.
But that the other council adds that the
In view of
rule in
the
question is literally mandatory, but by spirit it is not,
with due regard to the
regard being had to the past practice of the government. Any other point, any other advocate wants to say anything?
And your lordship has taken down that the order was passed on 29, 2025. The ordering person is furnished to submit the property statement details offline before the concerned superintendent of police in course of the day without fail. If such statement is submitted offline in course of the approved statement by the concerned, to do the needful in terms of letter issued by the state police headquarters under Annexure 1.
Yeah.
That means that would be considered in the DPC. And DPC conducted on what is the other date of conducting the DPC, the file date. And the date of conducting the EPC
No,
was
we want to know.
7/9.
We want to know. You said the rules, amended rule 21 or any other rule does not authorize the government or its secretaries to grant extension or relaxation.
I have to check up the service code whether that authorizes government to grant relaxation.
That you have to show now. We are in the hearing. That is the only case that is the only ground here.
And because it has been proceeding on a altogether different line, we have tangentially diverted from that to this now. That is why I am not prepared in that line. That I have to check up in service code. I cannot make an offhand statement that there is no provision or there is a provision, unless I am sure. Because that is a service code, I know.
Service code is there.
Yes. What is the service code?
There is a service code.
It's a
Statutory code. Statutory. It's promulgated under. Give that. But we under provision to 309 or 162.
I'm seeing one. It is 309.
Provision to 309.
British period of 309.
If it is
Article 241 of the Government of India Act 1935.
Government of India Act 1935. This was issued when? Before the advent of the Constitution.
Last and continued under Article 330.
313.
Yes.
372 I cannot understand. 313.
That is the written.
72 says all laws in force shall continue unless repealed. 313. That's transitional unit control. All the laws in force. Any post is or a service consistent this consolidation. 313 is in respect of service laws prior to the Constitution. They are
Rule 31, you are not saying to my
Rule 31 of the Orissa Civil
grants powers to the government.
itself provides.
rule.
Rule 31 of Orissa Government Servant Conduct Rules 1959 itself provides the power of relaxation reposed with the government.
With the government.
With the government. And amendment rule which your lordship is concerned about at present is only with respect to Rule 21. So all other rules of Orissa Government Servant Conduct Rules remained as it is, including the power of relaxation available under Rule 31.
Oh.
Read
Rule 31 of what?
Of the Government Servant Conduct Rule itself.
I have passed on Miller. That book I have passed.
1959.
1959.
Yes.
সে বইটা মধ্যে সে বইটা দিয়েছি
31.
মুজো বইটা দিয়েছি
Go to Rule 31.
গভর্নমেন্ট সার্ভেন্ট কন্ট্রাক্টগুলো মধ্যে দিয়েছি হ্যাঁ
Power of relaxation.
Government may relax all or some of the provisions contained here in respect of such government servant, particularly part-time and contingency paid government servant, as they may deem fit.
So this is the only power available, subject to a lordship's interpretation whether it encompasses everything or not. But the power available with regard to relaxation in the rule itself.
Rule 31 read with 33. 33.
Yes.
Miller. The 24 exercise by
সেটা হচ্ছে
But it should be by the government.
By the government.
Who is the government?
Yes, that, yeah.
Under the allocation of rules, transaction of business rules, allocation of business rules, the government entrusts these powers to particular set of its secretaries.
Yes.
Under that, you have to show this secretary has got this power, and it cannot be by a letter. It cannot be by a letter. It has to be in the form of an order.
Because
Otherwise, everybody will issue that letter for XYZ reason.
That means the entire promotion given to all, even our colleagues, that is also non-est in the law. That is the product of this also.
That is not the parameters of your litigation. In those some other case, if you bring, we may pass that order after hearing the other side. Government may relax. Government is defined under the General Clauses Act. Who the government is.
Yes.
So government functions through the secretaries.
yes,
So who should pass which order is decided under the allocation of business rules.
Rules of business. The rules of business.
Rules of business, whatever name.
Rules of business. That's the rules of business of our state also.
You have to bring the rules of business norms.
I have rules.
That is the only point of law I have argued today.
That will submit. Will be on that line. Will.
ସବୁ ଗୁଡା ଅଛି
That advocate is appearing to be responded banked upon rules 31 and 33 of 1959 rules, conduct rules, to support their contention that the government has power to relax any rule, and accordingly the additional secretary to government wide memorandum dated 27/11/2025 has relaxed the rigor of rule and extended the period for filing of property particular up to 31 January 2026. In that, all you have filed now.
We have filed. That is 31 May.
31 May.
Extended is 31 May 2025.
No, extension is
Last. Last one.
extension is
In January. Twice it has been extended.
extended up to.
Up to 31st May 2025.
Can that be May? November it is past and it cannot be May. May of 25.
Like there is a previous one.
This talking about the previous one. This is a letter 17/11.
No, you were talking
मेरा
about
27/11
19th April 2025. That speaks about 31st of May 2025. However, it is come to
27th November 2025 था देखो.
This property is not.
27th November.
Allowed by the government. What is the grace period allowed by the government?
That is
27.
That is
25.
This is the grace period this month, Milan. This is the month.
That
In this within the 35,
2026.
we have to submit. With
What is that? You are kindly read the last para 3 of the government letter.
if any defaulting, my lord, this is the grace period they have said by saying that detailed.
If any defaulting employee submit the required property return after the DPC with a grace period.
Within a grace period.
Yes, ma'am. Allowed by the government. And is found otherwise suitable for promotion.
No, otherwise
This letter
For a
itself.
moment, ma'am, for better clarity. Initially, it was 31st January
31st January of
2025.
25.
Yes, ma'am.
Yes.
Subsequently, by virtue of the letter, it was extended to February and subsequently it is on 31st May. Madam. These are the two grace periods.
No other extension is granted.
No, ma'am. I'm reading out 1 second. Madam. Keeping in mind the two dates. No, let me clear. 2 dates. Even after 1st January, as per the rules of 2021, if the grace period will be considered further, then it will be one is in the month of February and another is in month of May 31st. Ma'am. 31st May
Then
2025.
there was no necessity of issuing this letter.
No, we do not know.
It has been written, my lord, your lordship may kindly read
If any defaulting employee submits the required property return after the DPC
This letter
with a
itself
grace
is
period
different.
allowed by the government.
When the DPC was held,
7-9.
7-9.
7/9/25. DPC was held on 7/9/2025. Semicolon. Therefore,
ନାଇଁ ନାଇଁ ଏଇଟା ମୁଁ ରଖିଛି ଗୋଟେ ଆପଣଙ୍କୁ ଆଣିନି ନାଇଁ ନାଇଁ give a grace
any
period ନା
defaulting employee submits the property return
ନା ମତେ ଦେଇନା ମୁଁ ଆଣିଛି
after the DPC. Brother, what the learned counsel says appears to be sensible. See this. If any defaulting employee submits the requisite required property returns after the DPC, it cannot be May, and it can never be end of March, because this memorandum itself is issued in November 2025. And it says within a period after the DPC is held, and DPC is held on 7/9/2025. If that is so, it will go beyond the grace period, extended grace period.
Extended grace period is
Within a grace period allowed by the government.
But
Where the government has allowed.
AGA has considered before this Honorable Court that the grace period is
This letter,
31st March 2026 for the 2024. Paragraph 2 of that order, under 7/1/2026 order, Miller. May I read it aloud, Miller? It is submitted by Mr. Swasad Das, London Additional Government Advocate, that by virtue of subsequent circular and letters, the time to submit the property details for the year 2024 has been extended till 31st March 2020.
January
2020. So thereafter, can he say that this is not May 2025?
No. That was the previous one, not after the DPC. DPC is only if
7th November.
7th November.
After that, this is the first letter, Milan. Here it is, they have defined.
My lord has already understood.
Yes, the name of the secretary. Name of the secretary, name of the additional secretary. Both names you have to give.
Let's fix it to another day.
Order and reserved. Over. Yeah. Reserved.
No, one more solution from myself. The writ petition was filed with prayer to acceptance our property statement and allow us to participate in the process, and our case may be considered.
Yeah.
The honorable single judge passed interim order directing to accept our offline application, and without challenging that, government has accepted the same, or the authority has accepted our offline application. On the basis of acceptance, the order of this order was filed.
Read Order 43, Rule 1, capital of CPC, which is made applicable to writ proceedings.
That is my submission. That is your lordship.
Kindly look into that.
And what the honorable single judge has passed.
You don't want to read what the court is requesting?
Yes. No, I have no book. That's why.
You ask book, will give you. Just give the book. Give our book, CPC. Read Order 43, Rule 1, capital A of amended CPC. Any interim order pending during the proceedings, made during the pendency of the main proceeding, can be challenged in challenge of the order on the main proceeding. That is amendment. That is held to be applicable with
So what he says that,
proceedings.
that they didn't challenge the order, they accepted the order.
Therefore, they need not challenge intersection.
That's why, what is my submission, my lord?
Why can't you read that first?
Yeah.
Read the
Your
law.
lordship already
Legal
said that.
language we understand. We may be wrong also. Order 43, Rule 1, capital A of TPC, as interpreted by the Apex Court.
7A.
1A,
1A.
1 capital A.
Order 43, Rule 1. There.
Rule 1A.
Yes, anybody can read instead of spending time in turning the pages unnecessarily.
Right,
Sir, you only
right
read.
to challenge non-appealable orders in appeal against decrees.
That is made applicable
That is-
to rate to proceed.
That is not non-appealable orders.
That is
That is, I say that interim order is also appealable.
No, not appealable. Intra-court appeal, that order is not appealable.
So, my lord.
Those which have been made appealable under order 43(1) of CPC, CPC gives list of the orders which can be put in appeal under section 104 of CPC. We are only putting it so that you should not get offended when we say, otherwise you will not say anything and we will pass the order against you.
No,
Which option you want?
Then, no, your lordship
should tell you.
can't ask me that.
No, why
it
you tell
is,
this?
it is only a debate. I was
Debate.
I was telling him that I am already called in another court. Can I leave?
Correct.
Asking is,
When judges say something, it is a debate. It is a marketplace of
and
idea.
your lordship should take our submission
Also as a debate.
as a debate.
We always take.
That's
Therefore, we are asking this.
So the Honorable Single Judge disposed the matter on the finding that since CCRs have not been submitted by the concerned authorities, so it is time to accept our property statement and to consider their case. In view of the practice as have been made in the two judgments.
Counsel submit. The learned single judge has made an interim order dated.
Different date is there, my lord.
Section 141, by way of debate, Section 141 of the CPC says that it will not be applicable to read proceedings. But ordinary rules.
No, that is interpreted by the Apex Court. Unless that is interpreted, unless your read proceeding rules are contrary to that. That's how it is interpreted.
Yes, there are also decisions that strict pleadings.
Strict pleadings are not applicable. Even strict CPC is not applicable. But gist of the principles is made applicable.
That interim orders are not anything.
You don't have that interim order.
Interim order, what there has been mentioned in the final order.
In the final order itself, it is mentioned. In terms of interim order, final order is passed now.
Yes, ma'am.
See, you tell the defendant to make the payment subject to final order, and defendant makes the payment. Therefore, will you pass the decree?
No, that is subject to result, your lordship. That is subject to result is there.
So that amounts interim order is final order.
No, not final order.
Then the interim order is subject to final order.
Since it has been accepted, by offline application has been accepted, what are the intention of the Honorable Single Judge? And the CCR has not been submitted, and also they are willing to submit the property statement. So you accept that and consider this as has been held in the previous years. That was the case.
May I be permitted?
Yes. No problem. What will identity model permitting the respondents to file
Property statement
property particular, and the appellant having accepted the same
offline,
offline, Now they cannot turn around to file the appeal, challenging the order of the final order of the single judge. Yes.
That may I submit as a last chance. That rule 3, once again, may I read me? Rule 27th November 2023, clause 3. May I read once again?
Paragraph 3.
Yes, exactly.
If any defaulting employee submits
The required property return after the DPC
within a grace period
allowed by the government, and is found otherwise suitable
for
promotion, his oblique her promotion may be considered in the subsequent DPC.
Yes.
He or she may be granted notional promotion for the date
on which
his or her junior was promoted. For the next DPC.
Next DPC.
That will be retrospective.
Yes, retrospective.
And was promoted with seniority shall be maintained with a granted with a notional promotion.
What is meant by property returns after the DPC?
Yes.
Means after 7/11.
7/9.
7/9.
No, November 7, no?
7/9.
7/9. 2025.
Yeah, 2025. 7/9. 7/9/25.
Next DPC.
If it is after 7/9/25, then it is a extension only is the contention.
That will be considered for the next DPC.
We are not on DPC at all. We are on the requirement of filing a property deed. Then what will happen? Other things, the government will look after all that. We are on the very duty to file the property deed.
Yes.
Only on
Within the time stipulated.
within the time stipulated and extended by the secretary. They are saying like that. Otherwise, this letter has no meaning at all. This letter, to borrow your words earlier, 31/3/2025, 31 May 2025. That was the cutoff date, is your argument. That argument will not fit into the linguistic parameters of paragraph 3 of the OM. If you read paragraph 3 of the OM, it speaks of a particular
Date and DPC held.
DPC.
And even after that,
DPC
if at all DPC is held on 7/9,
7/9, which is after March, after May. And it also uses the word after the DBC within a grace period
within a grace period
by the
allowed
government.
by the government.
Government. Therefore,
And
it
found
has to be
authorized,
after
authorized suitable for promotion, then be considered in subsequent
in
DPC.
the subsequent this one, but that will relate back to the earlier this one, depending upon the seniority. Suppose in this DPC junior is given promotion.
That will be taken care of notional.
They will be given notional promotion, maybe above the junior.
But para 1, there are 3 clauses. On conjoint reading, my lord,
As per the
after careful examination of the relevant rules and provisions of the government, has issued the following clarifications. As per the Odisha Civil Service Criteria or Promotion Rules of 92, selection for promotion shall be made based of the merit and suitability in all respects with due regards to the seniority. Accordingly, any government employees who has not submitted the up-to-date property return at the time of DPC shall be treated as not suitable for the promotion in the DPC. And coming to the next clause, in that DPC, the DPC shall proceed
to fill up the
available vacancies based on the eligibility and suitabilities of the employees who have complied with the property returns requirements. No vacancy shall be kept unfilled
or reserved for
consideration promotion employees who fail to submit the up-to-date property returns. Then coming to the third one, if any defaulting employee submits the required property return after the DPC
Within a grace period.
within a grace period allowed by the government.
And is found otherwise suitable for promotion, he or shall be considered promotional promotion with retrospective effect from the first date of DPC, first promotion itself.
Notional limit.
Yes, wizard. Kind of give us the names of officer who passed those circulars.
Item 4, and in every circular, the language is, it is directed,
I am directed.
I am directed. The extension of timeline, can have a glance for page 20 for a moment.
I am directed. By whom?
The
I am
undersigned
directed
is
by myself.
directed to say that in terms of Odisha Government Service Conduct Amendment Rule of 21, every government servant from
If he says I am directed, there should be cabinet direction. He is saying I am directed to say like this. Therefore, there is a fight.
So there must be a government decision.
government
There must be a government decision. Unless we see, suppose if the government has taken the decision in terms of Rule 33, 31, etc., which the
earlier
has shown, then that will be decision of the government only, regardless of defective format. The format we cannot much bank upon, where in the file itself, the decision is available. You have to say whether a decision is available or not. No,
It must be there.
that must be there, my lord, because the language speaks itself.
You will not say I am directed.
I am directed. This is the language meaning. In all these 3 extension letters, 2 extension letters are there. It is in the 1st January, then 2nd February, 28th February, and the 31st May, my lord. 2 extensions are there after completion of the statutory period.
Next. On being asked as to why the secretaries have issued the letters, instead of government passing a formal order of extensions, come on, Government 88 submit that since the expression I am directed inwards is employed in the extension order, come on, there appears to be some orders by the cabinet
The cabinet is okay.
or competent authority.
The additional chief secretary may be a competent authority under the allocations.
Allocation business law. Competent authority like the additional secretary, etc.
Additional
In
chief
terms of
secretary.
additional chief secretary, etc. In terms of allocation of business rules. What is it called in your
Rules of business.
Rules of business.
Rules of business.
rules of business?
Secretariat rules of business.
Secretariat rules of business.
That book I can provide now.
Rules of business.
I can provide this.
Or you are not
And
simply
Odisha government.
that internal distribution.
No, that is there, madam.
These officers will exercise. These officers will exercise this power. In between, there is a distribution in between the additional chief secretaries. There are 2-3 additional chief secretaries and development commissioner and chief secretary. So that there must be a government decision allocating this.
There is one judgment of the apex court. Manohar Parikar versus
Yes.
government of Goa.
Goa.
Goa government.
Manohar Parikar was probably the chief minister of Goa.
Correct. There the apex court say, where particular business is allocated to particular officer, only he can pass orders.
That's right.
And orders passed by others are non-essential.
My little experience as an advocate general, I say that this must have been allocated to the 2-3 additional chief secretaries.
This is
One
not
government commissioner, chief secretary. So that must be an allocation within them.
is known as
Based on that judgment.
Odisha government rules. of
Odisha,
business. These rules may be called as
That Manohar Parikar versus so and so.
Goa.
Odisha government rules of business.
2000? No, not 2000. 2012, 30, something like that. 10, 11, 12, like this, not this. At least one assistance you can do. You can give your written submissions.
Short notes, written submission.
So that because now this point also arises. Suppose if the cabinet has taken the decision and we pass the order under the impression government.
That is what he has to
He
say.
has to say that.
Yes, ma'am.
He has
That
to
I
say
am
that.
coming. Well, I got that rule, my lord. Odisha government rules of business.
Yes. Orissa government rules of business.
156.
Yeah, that's also.
1956.
Yes, ma'am.
Under that, go to the schedule.
This is in exercise of the power conferred by clause 3 of the article 166
166.
of the Constitution of India and in supersession of all previous rules made in this behalf the governor of Odisha.
Go to the schedule. To whom the police, the departmental issues, staff selection, staff conduct, etc.
This is, my lord, the secretary definition means the secretary to the government of Odisha and includes a principal secretary, a special secretary, an additional secretary, a joint secretary, and a deputy secretary,
under secretary.
and under secretary.
चेक कर देंगे दे देंगे
We'll check up. We'll give it note.
We'll make a print of this and it will be easier to.
You give this one, but we have heard now. If you do not give, we'll make on our own research.
And one day time we give one day.
May I, do you immediately submit something?
Yes, sir.
But there are posts lying vacants. When there are 600 some odd posts were there, 400 persons were employed, rest 200 persons were there. We have already submitted the statement subject to what your lordship says. Statement. Government is in need of service, manpower.
They're going for
And we are, some of us are senior and some of us are given to understand when they stood fast in the selection. Like that, some candidates are there. 1, 2 candidates are there. So, no prejudice will be caused if you consider them and give them promotion. Only to throw them out on a technicalities and thereafter to give them, yes, would be at least a humanitarian note if your lordship can find it. That is my appeal.
We will have that also. Learned counsel appearing for the respondent submit. There is a huge vacancy in the police department
Of the year 2024.
for the year.
And then going to recruit from the retired persons.
And therefore, instead of hampering the public administration, his clients be permitted to but you have already filed your this one.
yes.
All of them.
The property details filed by his clients be accepted.
Already accepted because it has to be accepted by
As has been
31st.
done
Through HRMS.
by the
File
government in
HRMS.
terms of the interim order of the learned single judge. And thereby justice would be done to all.
And now because of the extension also, within 31st March 2025,
Especially in the
again we have filed in online.
January, 31st January.
Sorry.
Especially in view of the detention period up to 31 January 2026. Where is that order?
For online submission, that 7/11.
That is for the next
Does
year.
not say, but that does not say any date.
Yes, it has stated
Date also.
last line.
In the order they have filled.
This is for the 24. This is for the year 2024.
Then cut-off date was 25
No, that
January.
is submission made by the advocate.
That is for the year 2026.
Submission is made before the Honorable Chief Justice's court.
That's what task which has been made, giving a particular date.
Into brackets, the date aspect is mentioned in the coordinate bench interim order dated 7/1/2026. As a paragraph 2.
Yeah, the date is also mentioned. 31 January
That is the
2026
submission of the land
mentioned.
on instruction. Honorable Chief Justice narrated and on instruction it was submitted.
Then perjury.
You produce the file tomorrow.
One day we given.
Make order.
One day.
For production. It has to come from Punish. Huh?
No, one day, my lord, it is now.
Day after.
One day, day after.
Submit AG to produce the original file relating to extension of period. Periodic extension of the top line or filing of property particulars with the civil servants to show that the decision was taken by the government and letters were issued by the both are by additional secretary.
Yes, no. Additional chief secretary.
Both.
No, these two letters were.
This is by additional.
Not the additional.
This is my lord, additional secretary.
Additional secretary. Additional chief secretary.
Additional chief secretary last letter.
Last letter. November.
Prior to that, it was additional secretary.
You give that also. Yeah. Call this matter day after.
Yeah.
In the meanwhile, you bring your notes also so that it becomes easy for us.
Yes. This one, don't say the result. Suppose if there is a government order, if there is a government decision, six. Yeah.
Brother, we'll have it on the 9th,
Monday.
Monday. Because on Friday, I may not see. That's the reason. Yes, sir. You have to give the government advocate also to secure the name of the additional secretary and additional secretary who have issued those orders, letters of this.
Item 4.
Item 4, my lord.
Yeah.
That subject matter is pending with the Honorable Apex Court. Your lordship.
No, even though it has been pending, but it has been implemented. Your lordship can subject to result of the SLC.
Your lordship may kindly see order dated 21/7/2025.
When it is posted?
My lord, posted that I have annexed that order.
They have challenged the order of the Lawrence Central Administrative Tribunal. What is the order of the tribunal? Can you have a glance, madam?
Well, an order of the tribunal that whatever the order passed by the Honorable Delhi High Court in WPC number 5597 2014, that will be implemented in this case of the applicant.
Point number 1.
That has been disposed of in 23/10/2023, my lord. That is by the Delhi High Court in the batch of the cases at Annexure 10. That is
All India service matter.
Yes, my lord. The issue is granting of ACP, my lord.
Yes.
We have granted, but they have not satisfied that instead of LDC, lower division clerk, they insist for a technician, which is a higher.
Technician is higher post.
Yes, my lord. The scale is higher. And accordingly, my lord, that has been allowed and we have challenged before the Honorable Apex Court. Your lordship can kindly see the order I have annexed to the Honorable Apex Court
That is our. What is the order of the tribunal? They have challenged. Kindly have a glance, man. What is the order?
The matter is pending before.
Delhi High Court judge matter is pending.
Yes, ma'am. Yes, ma'am. That they have implemented. I have given. I have given that order.
They are implemented because there will be threat of contempt and other things.
My lord, that Honorable Delhi High Court, you also may kindly see the order of the Honorable Delhi High Court at Annexure 6, page 46. You also may kindly glance. 47. It is the interim order. Subsequently, I will show the Annexure 10. At page 47, you will kindly see. List this matter final hearing on 20th August 2015. In the meanwhile, save and accept the extent the partial implementation of the order has been already been taken place without disturbing the same. Rest of the implementation of the order shall be done still to the further order. My lord, this part has been, you will see, kindly say the final order passed by the Honorable High Court. At page 93, your lordship may kindly see, Annexure 11. The common judgment has been passed on 17th October 2023. 5 writ application, my lord. That has been dismissed and also clarifier has been made that partially that has been implemented and subsequently that has been implemented. This 5 writ application has been assembled before the Honorable Apex Court. And in one matter, you will also make an Annexure 12. That is.
When matter is posted before the Apex Court?
In my lord, in the meantime, what happened, my lord, due to the substitution of the LRs, some of the candidates that died, matter has been before the Honorable Registrar General. I am filing that statement as per the that has posted. You also may kindly see that.
The statement shows what?
The statement that matter will be taken up after 4 weeks.
After 4 weeks.
Yes,
but that will be?
That will be the end of that December, but thereafter this so that will be listed.
So in our order, we directed you to produce the order of
yes, ma'am.
Yes. You said that its order is implemented.
Yes, I have given the order. Kindly have a glance.
No, we believe you.
My lord, it has been mentioned that in portions of the letter that are such and such, DG Duradasan, Copernicus, New Delhi, in compliance of the Honorable High Court of Delhi in WPC 5597, filed by Union of India versus Residas, those orders they have stated, man. Against the order of the Honorable CAT, that is such and such, it has been implemented. Pension and pensionary benefits subject to the final outcome of SLP.
So, it is implemented means
subject to
subject to outcome of this one. Therefore, we will adjourn it for 4 more weeks. If they do not do something, then we may consider.
Yes.
Call up to 4 weeks. It's a request of learned senior panel counsel. Senior panel counsel appealing for the Union of India.
Interim order also there.
Who tells us that the larger question is being debated on the floor of the Apex Court, and case may be taken up, debated on the floor of the Apex Court.
My lord, the interim order is there, my lord. My lord, the interim order to extend.
Interim order to extend. Continue.
And they have given the status of that SLP. You lost in the side.
Yeah. Next.
That is cover matter in what such a place.
Item 12 is covered matter. Covered. The subject matter.
My lords, I am supplying copy.
Some same order to be printed.
कितना number?
Thank you for giving 2 copies.
कितना number case था? नहीं carry appeal number टा कितने?
16022.
This will dispose of that.
My appearance noted, my sub item 7 and 8.
Here in item 12.
Item 12, sub item 7 and 8.
Item 12.
Helmet.
Attend to mention.
No.
What is that? 40 matter.
My lord, item to mention.
The interim order is there.
Wherever entry models are there.
Item 35 also you model is like this. Item 35 will see 30.
33. 31 to 48.
No, my submission is there is a direction from the Honorable Supreme Court that it should be decided before 16th of February. And 16th of February. Can I just passing this order for the purpose? Can just pass it? In fact, there are now 2 times the Honorable Supreme Court has directed that it should be decided by the Honorable Court. And
16th of February.
yes, it will be listed for 16th, 17th, I'm so sorry. It was 17th of February.
Post it on.
Could I request let's put a bit on Monday or before that? Because I've come all the way from Delhi and I'm doing pro bono.
Okay. And can we have it on 10th?
Before Monday could be.
Before Monday?
Yes.
No, only tomorrow is the only day. Day after I am on leave.
Monday, coming Monday.
Can you have that on Monday?
Yeah, Monday. Yes.
But Tuesday we'll have that.
Tuesday, could have it.
Already they have it. So Monday already. All right.
Then to mention in note,
Item 35.
item 26, madam.
All just give
Item
if they are 25 matter, 24 matter, 1.
Then to mention my note, item 20.
Sorry, would that be given on
Yes.
Monday so that
Item 35 will entry model is there, Your Lordship. Item 35 entry model is there.
Wherever entry models are there, we are passing the.
Item 26, item 26.
There.